Strap in, folks. This case is a powder keg ready to explode. Right from the start, the judge is calling out lies, no contact violations, and even a shocking pregnancy reveal that takes the stakes sky high. We've got probation on the line, felony assault in the background, drug use, and a judge who has clearly had enough. By the end of this hearing, one wrong word could mean handcuffs on the spot. Stay tuned. You do not want to miss how this unfolds.
The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what...
Look this way.
What is... I don't
you
know
look
the
this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together, in that, in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well. Is that right?
Well, that's why.
They're pregnant now. Is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see kids.
And the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not worth.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? He was already staying at the house. We both our managers are in the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go. And obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there, and that's why you called?
Yes, ma'am.
Okay.
But
then
he's
it's
been staying there.
all right. Well, then you know what you have to do. You're the one
I got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house and you're, I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses. And so, all right, it means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for a felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, I'm going to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's the choice that you're making to still be with somebody that assaulted you. You can go back, go.
Thank you, Judge.
You can go with the bailiff.
You get an updated PSI?
Yeah. I wrote on the front page, but I also wrote on that other page where it was the update. Yes, ma'am. Thank you.
There's not an agreement, Judge, and I do have the complainant for the underlying offense as well as Ms. Lopez here. If she may come up, I think the court might need to admonish both of these individuals per my conversation with Ms. Lopez.
Okay.
If you've gotten to the point where you've frustrated Ms. Lopez, you know there's an issue.
So are we going to go through the motion?
Yes, please, Your Honor.
So let's do that first. Good morning, Ms. Lopez.
Morning.
And sir, you're Brandon Bell?
Yes, ma'am.
The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And will he waive the formal reading of the motion?
So
Give me just a second to get that pulled up. Mr. Bell, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to.
true or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Batterers Intervention and Prevention program. Is that true or not true? Have you done the BIP program?
No, ma'am.
Okay. So that would be true that you haven't successfully completed it, right?
Yes, ma'am.
Okay. Count 7 alleges that you failed to, that
I
you
think
fa-
it should say not in there, Judge, I'm sorry. You felt to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Failed to not, any objection?
Objection.
So 7, hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025, and is that true or not true?
True.
You understand adulteration means? If the court could explain adult, I don't think you.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No, ma'am.
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that or not? That you admitted to drinking
That,
something?
so it says you admitted to the adulteration of your urine analysis, that which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
No, ma'am. Any piss test I
Urine
had.
test.
Any
Urine,
any
listen.
urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer
Not that I
that
know
you,
of.
that you, did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true.
Count 10, let's see, actually count 9. Hold on, I'm out of 5, 6, 7, 8. What I missed here? Count 9, so this goes over here, alleges that you had contact with the victim of the offense, either in person, by telephone, via mail or through a third party several times after being put on probation in violation of your order. Is that true or not true?
You said it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025 in the amount of $337. And is that true? I'm going to find those counts true. Ms. Lopez is here. Let me look back at something real quick.
Hey, David. David.
When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with spinal top?
You mean mental health or
Mhm.
drug treatment? Mental health, yes.
Okay.
Yes.
Weaver.
Oh wait, Your Honor, I apologize. August 18th was his last drug test and he tested positive for THC. He has since been drug tested again in September and it was negative. I gave you the wrong date there. I apologize.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to this.
Not in here? Has there been any?
I was called by the complainant on Thursday of last week and she admitted that they had been seeing each other that day. And she was angry but it's very inconsistent whether she wants to be around him or not. Some days I get calls.
Well, but I told you.
To come back in front of you.
Just be quiet, listen.
I told you you can't have contact.
Yes, ma'am.
And you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some spinal top, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors in 15.17 and the fact that you're on probation for an aggravated assault.
What we've just witnessed is a courtroom drama that cuts right to the heart of why probation violations are taken so seriously. Let's break this down. At the center, we have Brandon Bell, already on probation for aggravated assault with a deadly weapon, a second-degree felony. That alone sets the tone. The court isn't dealing with a minor slip-up, but a man already walking on thin legal ice. Probation is essentially a contract with the court. You stay in line, follow the rules, and in exchange, you avoid prison time. Break those rules, and the deal is off the table. Now here's the kicker. Brandon wasn't just bending the rules, he was snapping them like twigs. The violations stacked up one after another. Positive drug tests, failed program requirements, curfew violations, falsifying urine samples, ignoring court fees, and, most damning of all, repeated contact with the victim despite a strict no-contact order. And remember, this isn't just any victim. This is the same person he was convicted of assaulting, now pregnant with his child. That revelation sent the courtroom into a whole new orbit of tension. Let's pause here. Many people misunderstand what a no-contact order means. As the judge clarified, it's not just about avoiding physical presence. It includes calls, texts, letters, even third-party contact. And yet, despite knowing this, Brandon kept showing up at her house, calling from jail, and trying to bend the rules of communication under the excuse of co-parenting. But the judge cut right through that defense. Co-parenting isn't the priority when one parent is under probation for assaulting the other. Safety comes first, period. The drug use element adds another explosive layer. THC positives, suspicions of synthetic drug use, and even an admission, later denied, of tampering with drug tests. In the eyes of the court, this isn't just reckless, it's defiance. It shows Brandon isn't just struggling. He's actively working against the system that gave him a second chance. And then there's the financial side. Court fees may seem small compared to felony charges, but being $337 behind is a big red flag. Courts see it as a sign of disregard for obligations. Combine unpaid fees with substance abuse and no-contact violations, and the scales tip heavily against probation being reinstated. What makes this case so gripping is the judge's tone throughout. No nonsense, no excuses, clear, firm reminders of what's at stake. You can almost hear the frustration, not just with Brandon, but with the cycle of poor choices, broken rules, and continued danger to the victim and children involved. So what's the bigger picture here? Cases like this highlight the razor-thin line between freedom and incarceration for probationers. One violation might earn a warning. 10 violations? That's essentially begging the court to pull the plug. And in this case, the judge made it clear. Protecting the victim, the unborn child, and the rest of the children comes before giving Brandon yet another chance.